The Trump trial has been scheduled. This one coming out of Florida. It has been fast-tracked. It's going to be scheduled for August 2023, which is very, very soon. Some might say right in the middle of an election season. But let's start here with the brief trial order that got filed out of the court. Here is what it looks like for us. Filed out of West Palm Beach Division, Southern District of Florida. The case is the United States of America versus Donald Trump as the defendant. This order came out from the judge in this case. Let's see who signed off on it. Eileen Cannon. She is back in the house. Remember, the original judge who issued the search warrant was Judge Bruce Reinhart, and Eileen Cannon is the presiding judge, the judge who this case is signed to, but she did not do the arraignment, and she also did not issue the protective order. The arraignment was done by another arraignment judge. Then the protective order was granted by Reinhart again. Now this is back over to Judge Eileen Cannon, who was a very favorable judge at the prior settings. When we were debating about the special master, we know that she was actually favorable. She was not buying the government's default good faith request to trust them when they were in possession of Trump's documents. So here is what the judge orders. She writes, "This case is hereby set for a criminal jury trial during the 2-week period commencing on August 14th. 2-week trial. We've got 38 counts, 37 counts. Pretty short trial for a lot of counts. 31 of those counts are documents, but I would imagine that you're going to have a serious set of examination for every single document. You're not just going to admit all 31 documents. And, it's going to be a long trial. So I don't think 2 weeks is enough. A calendar call, which means we're just going to finalize things, will be done about 1 week before on August 8th. All hearings will take place at one location. Parties are directed to bring any equipment that they need. So if you need an Elmo for overhead exhibits, or you need a projector, you got to bring your own stuff. All pretrial motions and motions in limine must be filed by July 24th. This is just crazy. Absent leave of the court, each party is limited to filing one motion in limine. If there is more than one defendant, which there are, defendants shall file combined motions unless a clear conflict exists. If it does, explain those conflicts. So this is now, we've got two defendants in this case. Walt Nauta, which was Trump's valet and sort of bag person, his personal assistant. Motions in limine may not, without leave of the court, exceed the page limits. It is further ordered as follows. All requests for writs ad testificandum must be filed no later than 14 days. In accordance with speedy trial reports with Local Rule 88.5, the parties shall file speedy trial reports every 21 days. All responses to discovery orders shall be provided timely in a fashion in accordance with dates. Notices must be filed according to the rules. All right, here we go. Here's some good stuff. Counsel shall be prepared to conduct limited voir dire following the court's questioning of the panel, right? So they're already giving us some limited jury instructions. Each party may file no more than 10 proposed voir dire questions, which is jury selection. So now we're talking about jury selection here. The court will not permit backstriking of jurors. So the judge will allow everybody to prepare 10 questions. The judge will ask all of the questions to the panel for jury selection. Then counsel may be able to ask limited questions of each juror. So we'll do 10 questions from each side by the judge, and in very limited questions, depending on what the judge allows, after those questions are provided. Jury instructions must be delivered soon. This all looks like, very form stuff. Prior to the calendar call, I want to know about your exhibits. Relabel them accordingly, GX1, GX2, DX1, DX2. Says no later than the first day of trial, the government shall provide the court with a tabbed binder containing copies of your exhibits. Any change of plea must be taken prior to 5 p.m. before trial begins. Trump's not taking a plea, so. Any motion for continuance, which I expect a lot of, shall set forth in detail why. Why do you need a continuance? Why do you need a postponement? Why do you need more time? And here's where we get into the complexities, right? This is where we're going to start to see some speed bumps in this trial road. What constitutes grounds for a continuance, including the complexity of the case? Yeah, 31 classified documents is going to be a lot. Also, the security clearance process. Yesterday on the program, we read through the notice of compliance from Trump's team. They've already said that they've started this process, but they've got to, I'm sure that's going to take some time. And also any anticipated Classified Information Procedures Act rules. You've got to follow all those. And 2, indicate the reasons whether the reasons served by granting the continuance outweigh the defendant's constitutional and statutory rights to a speedy trial. Okay, so this would be a situation, let's say, when we talk about time is very important in criminal law because the defense has a right to a speedy trial. Let's say you're charged with a DUI. And in fact, this is where this comes up a lot, actually, is DUI law. And they draw your blood. Well, you might say, hey, I have a right to a speedy trial. I want my trial in like 2 months, like right away. I want my trial next month. I plead not guilty. Schedule the trial right now. And some defense attorneys will do that. Why? Well, because the government might not be able to get all of the evidence back in time. If you have a complex DUI case that involves blood and your crime lab is backed up 18 months or maybe it's very bad like that. There was a situation where in Arizona we had a real bad backlog long time ago, and it was being delayed, right? So we would get blood results in some courts at the very last minute before the statute of limitations expired, and it would turn into this thing. But the point is, if defense demands a speedy trial and they don't have the evidence, the blood results back by the time the trial is supposed to start, they don't have the evidence. And so you can demand a speedy trial and push the government to provide it. And if they can't, then they have to dismiss the case, is the theory. So the argument here is that Trump has the right to exercise that. He can say, I want a speedy trial. But on the other end of that, he also has the right to due process. He has the right to confront his accusers. He's got the right to prepare his evidence and do his interviews so that he can properly present his case in a court of law. It's a due process argument. So Trump can't be forced to also go quickly. If Trump says, I need more time, Trump can waive the time. Defense waives that time. So if Trump says, hey, I need 60 days to go vet an expert and to get security clearance and to do all these things, the clock stops ticking for that amount of time because the defense waives it. So what I expect to see is Trump waiving a ton of time, motion for continuance, and making justifications under this exact framework. The judge is basically giving them, color by numbers here. Talk about your security clearance processes taking a long time and explain why Trump is waiving this, why he doesn't want a speedy trial. The filing by counsel of a notice of unavailability, follow the local rules. If you want transcripts, exchange those prior to the calendar call. All Janks Act material shall be turned over to defense counsel no later than the morning of the first day of trial. And that was material that they were intending to use during their direct exam. This came up, what trial was that? We just had a Janks issue. The material shall include a face sheet so the defense can acknowledge receipt. Upon receipt of this order, defense counsel shall certify with the courtroom clerk whether we need an interpreter, probably won't be relevant. Any proposed filing sent to the court clerk. If this matter proceeds to sentencing, the parties are advised to adhere to these procedures. If it goes to sentencing, that would be after a trial, or if they take a plea deal. I don't think that is happening. And so that is it. A lot of technical stuff here. Now, this is just a rough outline. I really don't think that these dates are going to hold. They're going to be flying around all over the place. And the likelihood that a trial takes place in August, I think, is very, very low. I do not expect that to happen. But the order came out, and so we do have an anchor, and we will continue to monitor that as that trial date moves around. We'll follow it and, of course, continue to cover the case. But Donald Trump sat down with a news anchor from a news website and got into a conversation about his candidacy. And as part of this conversation, we got to preview a little bit of what felt like a cross-examination. Remember, if this Trump case goes to trial, Trump might very well be a witness. And even if he's not a witness, these excerpts may be introduced as evidence against him, which is why defense attorneys get a little bit nervous, or very nervous, when defendants start talking about their cases, because anything that they say can and will be used against them. Now, in the court of law, that also applies to Trump. So these standards are good practices for everybody, including Trump. And remember, the DOJ is going to treat him like just a common petty thief. They don't think about the consequences of what they're doing here. That being said, Trump is getting a lot of criticism for this conversation and for this speech. But as we've talked about, I'm of the mindset that he has basically abandoned, in his mind, a defense in the court of law. I think he is putting all of his efforts into the court of public opinion. His end game here is not to win 4 different indictments. It's not to lose the presidency and win in New York and win in Florida and win in DC and then win in Georgia. That's probably not going to be a winning strategy. Something's probably going to stick on one of those 4. This is their shotgun approach. And no matter what you think about the federal entities and how corrupted they are, take a look at New York, for example, and what we already saw with the E. Jean Carroll trial. That was a civil trial, not even a criminal trial. So Trump's better strategy is to win in the court of public opinion. Literally, it's to win the presidency. His best defense is winning the presidency. And the people have the ultimate veto. They can just say, all right, we think these are all partisan prosecutor hack prosecutions, and Trump, if he is elected, will be empowered once again to pardon himself of these federal crimes and correct many of these wrongs. So we're watching this from both of those lenses. Yes, I think this will be likely introduced as evidence against him if this case goes to trial. And it's a preview of what the prosecutors are going to be asking if he were to take the stand. Here's what it sounds like.
Please, could we have it back?
And they
please,
asked for that.
Because they have no, we
They
were
did
talking.
ask for it.
No, and
they said,
I gave
can you
them
give the
some,
documents back?
and we were talking.
And then they said they went to DOJ to subpoena you to get them
Which
back.
they've never done before.
Right.
And in
but
all
why not
fairness,
just hand them over then?
Because I had boxes. I want to go through the boxes and get all my personal things out. I don't want to hand that over to NARA yet. And I was very busy, as you've sort of seen.
Yeah, but
I've
according
been
to
very,
the
very
indictment,
busy.
you then tell this aide to move to other locations after telling your lawyers to say you'd fully complied with the subpoena when you hadn't.
But before I send boxes over, I have to take all of my things out. These boxes were interspersed with all sorts of things, golf shirts, clothing, pants, shoes. There were many things. I would say
Iran war
much more, not that I know of, but everything was declassified. And Biden didn't have the right to do that because he wasn't president. Nor did Mike Pence, by the way, have the right to do that because he wasn't president.
All right, I'm not going to...
We zoom in and out on these things all the time. They ask about the specific allegations and whether those look good or not, and you can have an opinion about those. And then you zoom back out and you ask yourself, does Trump have this overarching capability to just declassify the documents? As we argued yesterday, he is the root power of the executive branch. And all of the other Presidential Records Acts and all of these other congressional frameworks are intending to limit the executive branch, right? This boils down into a separation of powers argument, one that to my knowledge has not been litigated before because Donald Trump is the first president ever to be prosecuted for a crime about documents that emanates, I would argue, from his root power as the chief executive of the country. Think of it this way. Congress created a Presidential Record Act by statute. It's not a constitutional amendment. So the Constitution, which gives Trump the actual final power over the executive branch, and he creates documents in his administration that are his. Congress, without an amendment to the Constitution, says we can handcuff you a little bit through this statute that we pass. What if the opposite were true? What if the executive branch just said this to Congress? They said, you know what? We think what you guys do with your SCIFs is a little bit problematic. And so what we're going to require is the Congressional Records Act. And I'm going to do this by executive order. I'm going to pass executive order called Congressional Records Act. And it says that Congress can do this, that, and the other thing with your records. Congress would say, get the heck out of here. And don't let the door hit you on the way out, brother, because that is not how this works. You don't get to tell us what to do with our documents and our records. But they can just pass a presidential record statute suddenly and they can control the executive branch? Why? Because they said so? No. So could Trump do it back their way? Could the executive branch go back to them? No, of course not. So this needs to be litigated, and it's going to be litigated. Everybody who says that this is a definite outcome and conclusion, I think, is a little bit off the mark because it's never happened before. Everybody has the same level of experience on this issue. Zero, because it's without precedent. Here's another clip.
I don't want to dwell on it, but according to the indictment, you were here at Bedminster on July 21st, 2021, after you're no longer president, and you were recorded saying that you had a document detailing a plan of attack on another country that was prepared by the U.S. military for you when you were president. The Iran attack plan. You remember that? You were recorded.
It wasn't a document.
Okay.
I had lots of paper. I had copies of newspaper articles. I had copies of magazines.
I know. This is specifically a quote. You're quoted on the recording saying the document was secret, adding that you could have declassified it while you were president, but, quote, now I can't. You know this is still secret, highly confidential. And the indictment cites the recording and the testimony from people in the room saying you showed it to people there that day. So you say on this on tape
it says just the opposite.
that you can't declassify it. So why have it?
When I said that I couldn't declassify it now, that's because I wasn't president. I never made any bones about that. When I'm not president, I can't declassify.
And that's what you said. You didn't declassify it.
I said no. I said I couldn't.
Could have
but that wasn't a
declassified
document, Brett. There was no document. That was a massive amount of papers and everything else talking about Iran and other things. And it may have been held up or may not, but that was not a document. I didn't have a document per se. There was nothing to declassify. These were newspaper stories, magazine stories, and articles.
I'm just saying what the indictment says.
Well,
the recording
people,
and the people in the room who testified.
These people are very dishonest people. They're thugs. They're thugs. If you look at what they've done to other people, what they've done to, and overturned in the U.S. Supreme Court, these are thugs.
The suggestion was that you wanted this as evidence that the military, the chairman of the Joint Chiefs, General Milley, had preemptively sent you plans for a possible attack on Iran, and that you didn't order that to happen. That's the suggestion.
I never ordered it to happen, no.
But that's why you wanted the document.
I don't think I've ever seen a document from Milley. Milley, frankly, was incompetent. The last one I'd want to attack with as my leader would be Milley. That I can tell you.
All right,
but I
last
think
thing on this.
I still like our alternative answer on this question better. I think it's a better explanation for what happened in that alleged phone call. First of all, it's an indictment. We want to know who recorded that call, who was in the room. We want to know a lot more details about that call, when that call was recorded. I got a lot of questions about the authenticity of it and so on. But the point is, we're talking about what is allegedly a classified document. Now, I want to distinguish between a document that is marked classified and a document that is actually classified. Right? A document could have been marked classified but be declassified and still have the classified markings on it, especially if it was declassified right before you moved, right when you were exiting the White House. This previously classified document that is marked classified is still marked classified, but it's now declassified. Okay, the status of the document has changed even though it still looks classified. So what Trump is saying is that it's marked classified. It's not actually classified. And I could have declassified it through the formal proceedings where it gets published on the White House, right? On the website, in a formal press release. You say, I'm officially declassifying this batch of records like Trump has already done. That's the better explanation. He's saying, I have this document, which is now declassified, but you can see it's a pretty serious document because it's marked classified. What I should have done is declassified it formally, but it's the same word being used essentially 3 different ways. And that, I think, is going to be the better defense here. The status of the document was declassified. He was being cutesy with it. I'll flash you the document. But that in and of itself wasn't possession of a classified document. It wasn't retention of national defense information. It wasn't obstruction because he retained it after they asked for it back. It wasn't any of those things. It was his document. And the Presidential Records Act doesn't govern it because that's Congress telling him what he can do with his own materials, and it's not a constitutional amendment. So here is Trump now comparing and contrasting the double standards that we see being exacerbated every day in this country under the Biden administration and their DOJ, saying that Trump gets abused, prosecuted for years for fake hoaxes, and the Biden people walk away with nothing.
Why did you have this very sensitive national security defense documents?
Because they're
like the
his.
War plans for a strike on Iran.
So like every other president, I take things out. And in my case, I took it out pretty much in a hurry, but people packed it up and we left. And I had clothing in there. I had all sorts of personal items in there, much stuff. And by the way, when Bill Barr, who's, a coward, Bill Barr was a coward. Bill Barr didn't do what he was supposed to do. I fired him, and he has great hatred, and that's okay, because some people do. And some people love me very much. He didn't resign. I asked him, give me a letter immediately, because he didn't have the courage to go after so many different things, and you and I have discussed it before. But he was a coward, and he obviously doesn't like me too much, and there are a lot of people that don't, and there are a lot of people that feel just the opposite.
But on the specific on the documents.
Let me just explain.
Yeah.
So I've got a lot of things in there. I will go through those boxes. I have to go through those boxes. I take out personal things. As far as the levels and all, everything was declassified because I had the right to declassify. You want to talk about a mess? Take a look at Biden, where he's got 1,850 boxes. He has boxes stored in Chinatown in D.C. He has boxes stored at Penn Center, and he has boxes under his Corvette and around his Corvette sitting in a garage for years where it was very seriously classified. I have every right to have those boxes. This is purely a Presidential Records Act. This is not a criminal thing. In fact, the New York Times of all had a story just the other day that the only way NARA could ever get this stuff, this back, would be please, 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 could we have it back?
And they
please,
asked for that.
Because they have no. We
They
were
did
talking.
ask for it.
No, and
they said,
I gave
"Can you
them
give the
some,
documents back?"
and we were talking.
And then they said they went to DOJ to subpoena you to get them
Which
back.
they've never done before.
Right.
And in
But
all
why not
fairness-
just hand them over then?
Because I had boxes. I want to go through the boxes and get all my personal things out. I don't want to hand that over to NARA yet. And I was very busy, as you've sort of seen.
Yeah.
So people are saying that that might be obstruction, right? He knows he's got the subpoena. I want to go through the boxes. The subpoena doesn't give him justification to continue to go through the boxes. The subpoena says that you have to give us those boxes and that he was not complying with the subpoena, right? So there is your obstruction. And I guess the thesis would be that he should have argued and challenged the subpoena at that time and said, no, I do actually have full authority to retain these documents rather than moving the boxes around and complying with them. Now, he's saying in response to that there are his boxes. He does not have to give them back at all. So it's further up the argument. It cuts off the entire, everything that hangs below it is covered. It's under the umbrella of they are his documents.
You then tell this aide to move to other locations after telling your lawyers to say you'd fully complied with the subpoena when you hadn't.
But before I send boxes over, I have to take all of my things out. These boxes were interspersed with all sorts of things, golf shirts, clothing, pants, shoes. There were many things. I would say
Iran war
much more.
Iran
not
war
that I know
plans.
of, but not that I know of. But everything was declassified, and Biden didn't have the right to do that because he wasn't president. Nor did Mike Pence, by the way, have the right to do that because he wasn't president.
All right, I'm not going to belabor
No,
this.
but
Brett,
when you
I
look
do
at
want to
this,
just get to the
other
specifics.
presidents, when they leave, they take the papers. They have thousands and thousands. Obama had it. Nixon had it. Carter had
Their
it. The
argument
Bushes
is that
had
these
it.
are super sensitive national security documents. All right, so here's,
I'm sure
I'm
you'll
sure.
see real super sensitive that Biden has, because
This is-
Biden has far more than anybody's ever kept.
and he turned them over when
No,
asked.
he
but-
didn't.
but
He
that's
still
what he
hasn't given
says.
the 1,850 boxes that's stored at the University of Delaware. In fact, they're fighting them in court,
Right.
and they're fighting them. And
But he
the
opened
boxes,
up for them to look at it.
excuse me, the boxes from
so did Trump.
Chinatown, he didn't turn them over. He sent them up to his lawyer in Boston to look at before they handed them over.
And there are special counsels looking at that, and we'll see what comes out of it.
Yeah, we will see, Brett. We will see what comes out of that. Let's see. Nothing, I'm going to guess, because it is one set of standards for one person and an entirely different set of standards for another. And you know, Trump lives in the shadow of Hillary Clinton. That was a huge part of his campaign in 2016. It was her classified documents, her emails. The FBI didn't prosecute her at all. They contorted themselves and came out and they transmogrified the entire statute to change it from grossly negligent to extremely careless. And they decided not to prosecute her. So Trump was acting according to the Hillary Clinton standard. Unfortunately, we live in a world of double standards, and he doesn't get the benefit that the favored defendant class gets.